Donald Trump has been indicted. Well, that is the news on the street, coming from Donald Trump, actually. And while we don't have all the information, it looks like the coming indictment is not over what most people thought. It looks like Manhattan District Attorney Alvin Bragg will indict Donald Trump for the crime of falsifying business records. What business records, you say? Well, the business records showing payments to adult film actress Stormy Daniels. Trump's former lawyer, Michael Cohen, went to prison for, among other things, facilitating a keep quiet payment to Daniels on Trump's behalf. And while the facts are simple, the law is not. Falsifying business records is generally a misdemeanor. To make it a felony, New York prosecutors would have to show that Trump had actual intent to commit another crime. The prosecutor might argue that the hush money payments was intended to violate campaign finance laws, which is all a can of worms. So, how did we get here? Now, in case you were in a Rip Van Winkle style coma and have just woken up, hold on to your wig because I have some news. In 2016, the host of The Apprentice was the Republican nominee for president. On October 7th, 2016, the Washington Post published a video showing Donald Trump and a member of the Bush family making some lewd comments about women. And while Trump was battling the so-called Access Hollywood tape, Stormy Daniels, a prolific entertainer in adult films, threatened to go public after her alleged affair with Trump. Michael Cohen, who was then Trump's personal quote attorney slash fixer, facilitated hush money payments to Daniels. The payments were meant to keep Daniels quiet so that Trump would win the election, at least according to Cohen. Now, the Access Hollywood tape was thought to be the death knell for Trump's campaign, and it caused many politicians to back away from Trump without really backing away from him. But despite the rumors and the Access Hollywood tapes, Trump won the election. Now, during that frantic time, however, no one knew how the tape would impact the campaign. Trump and his advisors had already anticipated that women would go forward to the media with claims about Trump, and they came up with a plan to deal with it. In 2015, Trump and Cohen met up with David Pecker, the chairman of American Media Inc., the company that publishes the National Enquirer and other tabloids. Pecker agreed to help Trump fend off claims from all the women he definitely did not have affairs with over the years. And at Pecker's direction, the National Enquirer and other tabloids agreed to catch and kill stories about Trump by negotiating for the exclusive rights to the negative stories about Trump and then never publishing the stories they paid for. Now, 6 weeks before the Republican National Convention, former Playboy bunny Karen McDougal was set to go public about her alleged affair with Trump. In June of 2016, however, Pecker's company purchased the rights to McDougal's life story for $150,000. Pecker then assigned the rights to Cohen for $125,000. Cohen incorporated a shell company called Resolution Consultants LLC to receive the money. Now, he secretly recorded a conversation with Trump explaining the arrangement.
I need to open up a company for the transfer of all of that info regarding our friend David, so that I'm going to do that right away. I've actually come up and spoken to me.
And when Cohen told Trump that they have to come up with some financing, Trump suggested paying by check or maybe even using cash.
So I'm all over that. And I spoke to Alan about it when it comes time for the financing, which will be...
Listen, what financing?
We'll have to pay you. So
I'll pay the kid.
No. I got no.
Now, obviously, Cohen decided to use a shell company here because ostensibly he was a lawyer. Pecker sent the paperwork to Cohen, but then backed out of the deal. However, Pecker kept his antenna up for other women who were shopping stories about Trump. In October of 2016, Pecker told Cohen that porn star Stormy Daniels was willing to sell her story and was already in talks with Good Morning America. Cohen negotiated an agreement with Daniels to purchase her silence for $130,000. And to arrange a payment that was not linked directly to Trump, Cohen drew down $130,000 from his home equity line of credit and requested that it be deposited into the bank account of another shell company, Essential Consultants. Cohen then wired $130,000 from Essential Consultants directly to Daniels' lawyer. Now, the paperwork required for the wire transfer indicated that the transaction's purpose was a, quote, retainer. Now, spoiler, that's not what a legal retainer is or what it's for. But after the transaction was complete, Daniels signed a confidentiality agreement and side letter agreement with Cohen. Everything worked according to plan. And in 2017, Cohen started invoicing the Trump organization to recoup the money. And the payments were broken up after pay style, so that every month, Cohen submitted an invoice for $35,000 that stated, quote, pursuant to the retainer agreement, kindly remit payment for services rendered for the relevant month. Now, according to the Justice Department, quote, in truth and in fact, there was no such retainer agreement, and the monthly invoices Cohen submitted were not in connection with any legal service he had provided in 2017. Now, the Trump organization labeled the payments legal expenses, and by the end of 2017, the payments to Cohen totaled $420,000. And the payments were apparently grossed up for tax purposes, because otherwise Cohen would have to pay tax on the income and not be fully reimbursed for the payout. So Cohen billed $360,000 for the claims and also got a $60,000 bonus. Now, what did Trump say about all this? Well, the usual. He'd never have an affair, and if he did have one, it wouldn't be with Stormy Daniels. Eventually, Trump got around to admitting that he worked with Cohen to pay Daniels off, but he said that there were, quote, no campaign funds going into this, which would have been a problem. And in May of 2018, things went from bad to worse when Rudy Giuliani got involved and confirmed that the Daniels payment was
funneled through our firm, and the president repaid it.
And as per usual, Rudy stepped in big time, telling Hannity that Trump needed to pay off Daniels to influence the election. Quote, imagine if that came out on October 15th, 2016, in the middle of the, last debate with Hillary Clinton. Cohen didn't even ask, Cohen made it go away. He did his job. Rudy tried to backtrack by saying that the main concern wasn't the election, it was the allegations hurting Trump personally. Quote, it wasn't for the campaign, it was to save not their marriage as much as their reputation. On May 3rd, 2018, Trump tweeted an admission that he repaid Cohen for the Daniels settlement through a monthly retainer. On August 22nd, 2018, Trump said these payments weren't a campaign finance violation because they, quote,
Came from me, and I tweeted about it.
Of course, what Trump is leaving out here is that the $35,000 installment payments were definitely not for legal work Cohen was performing for him each month. During the investigation, Trump Organization CFO Alan Weisselberg and David Pecker cooperated and were granted immunity. Cohen, for his part, pleaded guilty to 2 campaign finance violations, testifying that, quote, Donald Trump directed him to commit a crime by making payments to 2 women for their principal purpose of influencing an election. Cohen's payment was considered an in-kind contribution to the 2016 Trump campaign. Cohen could only lawfully give $5,400 to support Trump's candidacy at the time. So the $130,000 payoff violated the law because it was too big. Now, Cohen also pleaded guilty to paying off Karen McDougal, which violated a federal law called the Tillman Act. Now, the Tillman Act bars corporations from spending in federal elections, and Cohen was sentenced to 3 years and released early. Which brings us to AMI. Now, the campaign finance law prevents corporations from spending money to influence elections in coordination with the candidate or campaign. Prosecutors said that AMI's payment to McDougal amounted to a secret in-kind contribution to Trump's campaign. During the election, the National Enquirer ran headlines about Hillary Clinton's sleazy affairs, even accusing her of paying off reporters to bury the truth. But it never ran a negative article about Trump. AMI admitted to meeting with Trump back in 2015 to help him handle negative stories that could have impacted the presidential campaign. The company admitted negotiating with McDougal at the direction of Michael Cohen. It also admitted paying $150,000, which was much higher than the company's normal rates because the company had Cohen's promise that he would pay it back. AMI's deal with McDougal was extraordinary in another way. Pecker promised her that she would get 2 magazine covers and that the company would publish 100 articles written by McDougal. AMI entered into a non-prosecution agreement with the DOJ to avoid liability for its illegal role in this payment. Now, you could look at this deal as the DOJ giving AMI a slap on the wrist. The company wasn't prosecuted or even fined, even though it admitted to violating the law. Instead, AMI was required to develop compliance programs, and Pecker kept his job. But on the other hand, the DOJ could say that the non-prosecution agreement was worth it since it gave the DOJ enough ammo to prosecute and convict Cohen. But then what about Donald Trump? Trump was not referred to in the criminal information against Cohen, but he was memorably known as individual number 1. Cohen has told everyone who would listen, including Congress and a New York grand jury, that Trump was personally involved in or briefed about the Daniels agreement every step of the way.
Yet last fall, I pled guilty in federal court to felonies for the benefit of, at the direction of, and in coordination with individual number 1. And for the record, individual number 1 is President Donald J. Trump.
So why wasn't he prosecuted for violating the Federal Election Campaign Act? Well, Cohen was charged with violating FECA. The law limits donations by individuals and bans corporations from making any contributions to candidates. Hush money payments are illegal contributions if they are deemed to be in-kind contributions to the campaign. And according to the FEC, any expenditure that a person or entity makes, or cooperation or consultation in concert with or at the request or suggestion of a candidate's campaign is also considered an in-kind contribution to the candidate. The FEC also says that the value of an in-kind contribution, the usual and normal charge, counts against the contribution limit as a gift of money does. And these contributions have to be reported to the FEC. Cohen's payments to the 2 women went over the donation limits and were not disclosed. And as a presidential candidate and as president, Trump was required to file annual and personal financial disclosure reports that detail various financial holdings, income sources, and debts. Trump's 2017 financial disclosure did not disclose a debt to Cohen or a Cohen-related entity like the ones described by Giuliani. The McDougal payment was an obvious violation of the law because a corporation, AMI, paid money money to McDougal. And most campaign finance violations are treated as civil cases, but when someone admits to knowingly and willfully violating the law, the DOJ will file criminal charges. Sometimes. Now, the DOJ could have charged Trump, but at the time, his DOJ followed the Watergate-era DOJ memo about not indicting a sitting president, which of course is controversial in its own right. Now, we've talked about this policy before and the reasons why it's probably not correct, but every DOJ has followed it so far. And so why didn't the Justice Department charge Trump after he left the White House? Well, sources said the prosecutors were worried about the reliability of Cohen as a witness, particularly since he was charged with lying to Congress about a project Trump had going on in Russia. And the prosecutors also concluded that new witnesses were unlikely to come forward. So New York City District Attorney Alvin Bragg can't prosecute Trump for federal campaign finance violations. So how can local prosecutors make a case out of the old Daniels payment? Well, Bragg charged Trump with falsifying business records by recording Cohen's reimbursement for the Daniels payment as legal fees. But that's only a misdemeanor under New York law, unless prosecutors can prove that he falsified records to conceal another crime. New York Penal Law Section 175.10 makes it a crime to delete, alter, or make a false entry in the business records of an enterprise with the intent to defraud. This is a misdemeanor charge unless prosecutors can prove intent to further or conceal another criminal offense. The maximum sentence for a misdemeanor conviction is up to 1 year in jail, while the felony offense carries a potential penalty of up to 4 years. Now, the statute of limitations is 2 years for the misdemeanor and 5 years for the felony. Now, to get a conviction for falsifying business records, the government has to prove the following beyond a reasonable doubt: that someone makes or causes a false entry in the business records of an enterprise, or 2, alters, erases, obliterates, deletes, removes, or destroys a true entry in the business records of an enterprise, or 3, omits to making a true entry in the business records of an enterprise in violation of a duty to do so, which he knows to be imposed upon him by law or by the nature of his position, or 4, prevents the making of a true entry or causes the omission thereof in the business records of an enterprise. Then to prove felony falsification, the government has to prove those elements plus one more: that the person's intent to defraud includes an intent to commit another crime or to aid or conceal the commission thereof. Now, a defendant who requests that someone else do the actual work of recording a false business record can be just as criminally liable as if they did it themselves. And there could be other crimes that could lead to a felony enhancement. New York state elections laws could be a predicate offense for the record-keeping violation, even though the presidential contest was a federal election. Article 14 of the New York State election law and Part 6200 of the New York State Board of Elections rules and regulations govern campaign finance. These regulations govern everything from the time and place to file campaign disclosure reports to the violations and penalties for failing to abide by the rules. For example, New York Elections Law Section 17-1752, which covers conspiracy to promote or prevent an election, says that, quote, any 2 or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means, and which conspiracy is acted upon by one or more of the parties thereto, shall be guilty of a misdemeanor. And there are a number of New York elections law that relate to the expenditure of funds in furtherance of one's campaign. Or additionally, it might be related to a tax evasion crime, since theoretically he would have taken a business deduction related to the payments to Cohen. So why is Alvin Bragg acting now? Well, we don't know for sure, but maybe there's new evidence. The Wall Street Journal reported that in September of 2016, Cohen refused to pay off Daniels, but he changed his mind in October right after the Access Hollywood tape was released. If true, this would create an inference that the payments were meant to influence the campaign, just like Pecker and Cohen said. In addition, the New York Times reported that the day before Cohen wired the $130,000, he spoke to Trump twice by phone. On the day after the payment, Cohen and Trump spoke again. Giuliani said the campaign did not want to have the Daniels bombshell dropped during a debate with Hillary Clinton. The grand jury recently heard testimony from Kellyanne Conway, and we don't know what she said, but as a key advisor to his campaign, maybe she testified about whether the payment was made with a debate in mind. And remember, at the final debate, Trump had set up a stunt. His guests were some of the women who accused Bill Clinton of assault and sexual harassment. So how would it have looked if the Daniels bombshell had dropped before that debate? But it should be noted that there are also some serious statute of limitations issues. The New York statute of limitations for most felonies, including the ones we've discussed, is 5 years. For misdemeanors, just 2 years. And the conduct at issue here occurred largely in 2016, more than 5 years ago. Though maybe there was some undisclosed conduct that continued past 2016. One possible exception is when the potential defendant is continuously outside of the state. Trump rarely went to New York during his presidency, but this law is mainly mainly intended for criminals who leave the state and hide. Not really the case here. There was also former Governor Cuomo's executive order tolling the statute of limitations for most crimes because of the COVID emergency. New York courts have ruled that the order told the statute of limitations, giving most claims an additional 228 days. But at the moment, it's unclear what Bragg might be relying on for the statute of limitations issue. Now, Trump has said this is not a state case, it is a federal case, and they have all passed on it. And in some ways, Trump's assessment is correct. The DOJ prosecuted Cohen and penalized AMI for conduct both parties did to help Trump win the election. That gave the Department of Justice a prime opportunity to prosecute him, but the DOJ passed. In addition to arguing about the statute of limitations, Trump has other good defenses to the felony prosecution. First of all, it's not clear that the prosecutor can use a violation of federal law as the basis for the felony enhancement. A court could rule that falsifying business records is only a felony if it, quote, aided or concealed a New York state crime, not a federal one. There could be other federal crimes implicated by Trump's conduct, like wire fraud, but again, this is a federal crime, and some lawyers in the DA's office have reportedly thought that they could not charge Trump with falsifying a business record to commit a federal crime. Now, the statute also says, quote, a person is guilty of falsifying business records in the first degree when his intent to defraud includes an intent to commit another crime or aid or conceal the commission thereof. So does the phrase another crime mean that it can be any crime, state or federal? We don't have a definitive answer, and the statute is unclear, and there's no case law interpreting the phrase another crime. Bragg can certainly argue that there have been many similar prosecutions for falsifying business records to cover up a federal crime. As reported, Trump's CFO, Alan Weisselberg, was just convicted of a state felony based on false entries made in federal tax forms. If a judge agrees that the federal campaign violation is viable, then Trump will then defend himself on the basis that he did not have the intent to violate the law. His argument here could be decent. His own tweets show that he doesn't really understand campaign finance law. He's shown confusion about whether it's legal for him to use his personal funds to reimburse a loan from Cohen to the campaign, for instance. And in Cohen's case, the DOJ asserted that contributions and expenditures under FICA include just about anything that could influence a campaign. But is paying off a mistress truly a campaign expense that is designed to influence a campaign? FICA is a complicated law with lots of nuance on how it's interpreted, and Trump doesn't exactly seem like a guy that grasps the nuance of these kinds of laws. And Trump has already raised the advice of counsel defense. To prove that defense under New York law, Trump would have to show that Cohen told him that Daniels' payments were legal and that he relied on Cohen's advice in good faith. That's not exactly a defense so much as a way to show he doesn't have the requisite intent under the law. And this could set up a he said problem for the jury. You know, will they believe Cohen, a prosecuted liar, or Trump, just an extremely well-known liar? And Trump can attack the prosecutor's claim that he misrepresented the payments to Cohen, quote, with the intent to defraud or instructed someone else to do it for him. The federal prosecution of Cohen didn't come to that conclusion. In the Cohen sentencing memorandum, the DOJ said that Cohen submitted bogus invoices, quote, at the instruction of an executive for the company. Was that executive Donald Trump or someone else, maybe Alan Weisselberg? This sets up a classic "it wasn't me" defense for Trump, which is something that he's wielded well over the years. And it might seem unfair for Cohen to serve time for something he did at Trump's direction, but that's sometimes what happens when you have a slam dunk case against a subordinate and you have all of these intent and other motive related questions for the people that are higher up. Of course, if Trump is arrested, he'll want a nice home-cooked meal before he goes to jail. And the best way to do that is with today's sponsor, HelloFresh. HelloFresh is a great way to eat delicious, fresh food while still being healthy. It's a great way to get back into a diet or just eat great food. In fact, HelloFresh has a whole variety of calorie-smart, carb-smart, pescatarian, and veggie options, so you can customize it how you like. HelloFresh delivers fresh, quality produce from the farm to your door in less than a week, so you can enjoy favorites like soy-glazed salmon with rice or mushroom and chive risotto. I usually go with the high-protein options like one-pot pork and black bean chili, or creamy Dijon dill chicken. Now, I'm a do-it-yourself person, and I have to say, I was initially pretty skeptical about HelloFresh. I'm a pretty good cook, so I didn't think that I needed the help, but I actually loved it. Even for an experienced cook, HelloFresh delivers new ingredients and recipes that I'd never try on my own. And of course, everything was delivered straight to my door, so I didn't have to do any of the shopping. The produce actually gets to you faster than a grocery store, so it arrives at peak freshness and flavor. And it's also super easy to save time. HelloFresh cuts out the meal planning and prep, so the recipes take only 20 to 30 minutes to cook, literally less time to cook than it would normally take to do the shopping. And it's also incredibly sustainable. Since the ingredients are pre-portioned, there's less prep and less wasted food, and the packaging is almost entirely made from recyclable or already recycled content. And HelloFresh's carbon footprint is actually 25% lower than that of meals made from store-bought groceries, and 72% cheaper than dining at a restaurant. So if you'd like to try HelloFresh, go to HelloFresh.com and use the code LegalEagle60 for 60% off plus free shipping. Yes, you can actually get 60% off plus free shipping by clicking on the link that's on screen right now or down in the description. So click on the link that's on screen right now and go to HelloFresh.com and use the code LegalEagle60, or just click on the link below. Plus, click on that link, really helps out this channel. After that, click on this playlist over here for more Legal Eagle, or I'll see you in court.